Welcome once again to Lehto's Law. Here's Steve Lehto.
Bernie tipped me off to a crazy case out of Massachusetts. And it's one of these cases that when you see the headlines or the summaries, it really makes you wonder. But when you hear the reasoning behind it, it makes complete sense. And privacy advocates, of whom I have many in my audience, are going to applaud this decision. But what happened here was the police were called to a home. The police went inside the home. One of the police officers was wearing a body camera. The police took care of the business they had in the home and they left. A little while later, someone at the police department said, "Hey, wait a second. Does somebody have footage from inside that home that we can see?" And somebody goes, "Yeah, I've got it right here on a disc." And they give them the disc and they watch the footage. And in the footage, they recognize something that's distinctive that will help them with another case. And they sought and got a warrant based on the fact that what they saw on the body cam footage helped them get the last piece to a puzzle to get a search warrant. They then executed the search warrant, went into the home, and found what they were looking for. And then they brought the guy up on charges. We'll get to that in a second. But on appeal, the guy argued and said, you got the information from the body cam, and the body cam was being worn in a different instance. And so the fact that you can then later just dig through the body cam footage and find something seems to me it's a violation of my constitutional rights. And a court agreed. And a court said, yes, the police officer is allowed to wear the body camera. And if it records something that is pertinent to the case as to why he got called there, absolutely. But digging through the footage later is a violation of your rights. So the story comes to us from a case that actually got handed down just a couple weeks ago in Massachusetts. And it says, responding to a call about a domestic disturbance at the defendant's home, a Boston Police Department officer who was equipped with a body camera created a digital recording of the encounter. The recording captured the intimate details of the parts of the home through which the officer traveled as he provided assistance. The resulting video footage was stored by the Boston Police Department and then retrieved and reviewed without a search warrant in connection with an independent investigation to confirm a suspicion that the defendant was engaged in criminal activity. On the basis of that review, the Boston detective obtained a search warrant to search the home. That search subsequently yielded a firearm and ammunition, which apparently was something that would raise this to the level of a crime. The defendant brought a motion to suppress the fruits of the search, but it was denied by the Superior Court judge. After a trial, the man was found guilty. Up on appeal, there's two issues of first impression in Massachusetts. First, whether the warrantless use of the body-worn camera comprised a violation of the Fourth Amendment. And second, whether the subsequent review of the footage obtained for investigative purposes unrelated to the incident giving rise to the creation constituted a warrantless search. We conclude that the use of the body-worn camera within the home was not a search in the constitutional sense. It documented the officer's plain view observations during his lawful presence in the home. He's there lawfully, he's got eyes. The body camera, assuming it's on his chest, is recording pretty much what he's looking at. And so what he's looking at, he's not violating the Constitution because he was brought in there, presumably by somebody who gave him permission to be there. And so he's there, he's got eyes, that's okay. But they say that the later investigatory review of the video footage, unrelated to the initial call, was unconstitutional. That review resulted in an additional invasion of privacy, untethered to the original authorized intrusion in the defendant's home. Absent a warrant, it violated the defendant's right to be protected from unreasonable searches guaranteed by the Fourth Amendment. And so there's actually a 35-page opinion here. I'm not Leonard French. I'm not going to read all 35 pages to you. And I love Leonard, by the way. I'm sure you know that. At least he knows that. But it was back in February of 2017 that the officers responded to a dispatch call regarding a domestic disturbance request for a removal of an individual at the defendant's residence. And I'm going to summarize because I ain't got that kind of time. And so the police show up at the house, and there's somebody in an upstairs room that the people who own the house or have the right to be in the house. I forgot if they're tenants or they own it. They said, I want that person out of here. That person won't leave. I want them out of here. Police show up and they realize this might get touchy. So a couple cops go up the stairs, including one who's wearing a body camera. Now they go up the stairs and they open the bedroom door where the person is who won't leave. And they say, what's going on? And the person goes, look, I'm getting my stuff together. I'll be out in a second. And apparently it's a woman they're asking to leave, and there's a man who's with her. And he says, look, she's getting her stuff together. Just, guys, calm down. We'll be there in a second. Police go, okay. And then woman gets her stuff together and she leaves. The police leave. It's the end of that interaction. And so the police were in the home for a brief period of time in response to a domestic disturbance call and to remove somebody from a home. That's it. And the person, by the way, left under their own power. They weren't dragged out kicking and screaming with taser wires hanging off them. So the person left the home. Later on, the Boston Police Department is working on a case. And in that case, there's a guy who shouldn't have guns. And apparently they think he does because he's posting on social media, posing with them. And so they're looking at this going, he's posing with these. He's not supposed to have these. But, the argument's going to get made if they arrest the guys and they go, I don't know what you're talking about. Those photographs were taken years and years and years ago. I don't know, And so the police are thinking about this. Detectives are thinking about this. They're going, how could we... Really, the only way we could prove that he's in possession of those without, just speculating would be to catch him with them, okay? And somebody says, well, he's shooting these videos and these TikToks and these Instagram photos and probably Facebooking, I don't know. He's putting this stuff on social media, suggesting he's got these. Where do you think he's shooting the videos? Somebody goes, well, he has a connection to that house where there's a domestic disturbance call a little while ago. I wonder if anybody's wearing a body cam. And they asked around. A guy goes, yeah, I was. And I saved it. You want to see it? So then they pull the body cam footage out and they watch the body cam footage. And as they go through it, police officer goes up the stairs, the bedroom door opens a little bit, and the body cam catches the image of the room. And in the room are some very distinctive curtains. Okay? Curtains. Very distinctive curtains. Kind of like if you had a photograph that showed that wall. You'd have no argument saying that could be another wall. No. Trust me. This is the only wall in all of time, space, and dimension that's looked like this. Okay? So that wall is unique. Apparently, these curtains were of that same level of uniqueness. So the police then went and got a warrant based on the guy post videos of himself in possession of something he's not supposed to be in possession of, in front of these curtains, and based on this video, we can prove that these curtains are in that house. We want to go in and search the house to see if that's where the guy keeps his stuff. And a judge signed off on it and said, yep, go ahead and do that. And it was fought at the trial level, and they lost. But on appeal, the Massachusetts court said, yeah, this is actually something that is a concern. And the concern is, again, a police officer, if he sees something with his own eyes, it's called the plain view doctrine. If he sees something, and I've mentioned before examples, although some of my examples get people really, really upset for some odd reason. But let's suppose a police officer walks up to your car in broad daylight on a sunny day, and as he's talking to you, he looks in the back seat and sees something that shouldn't be there. You can't say, well, hey, he searched my car without my permission. Yeah, it wasn't obtrusive, number one, but number two, he's just looking. He's using his own eyes. He didn't just literally looked, and there it was. There it was. So the trial court apparently said, you know something? The body camera is basically plain view, right? It shows what the police officer saw. If that's true, why didn't they ask the police officer, will you sign an affidavit saying that there's these distinctive curtains in that room that you looked into a while back? Apparently, he didn't remember it. If he did, he could have signed the affidavit. But instead, they went through the footage, found it there, and said, hey, look, we've got footage that was shot. There you go. Now, I know some people are going to say, Steve, this is too far. The footage was there, and to suggest they need a search warrant to go through the footage is kind of absurd. Not really, because if you think about this, when police officers show up someplace and they see something with their own eyes, you expect them to go, oh, there's something I need to respond to. If they didn't catch it then, but they're digging through footage later of the inside of your house, you, I hope, can see that there's a little distinction there, that they're invading your privacy by looking at this footage over and over again. The body cam footage, generally speaking, is to record what the police did on that day and time at that place. That's what it's there for. It's not there for them to dig through later looking for clues as to what they might have missed while they were there. So the court said specifically that the police officer was allowed to be there. He's allowed to shoot the footage. The footage could be used for the purposes of what happened on that call. But to dig through it later is a violation of the unlawful search portion of the Constitution's Bill of Rights at number 4. Coming in at number 4, unlawful search and seizure. So there you go, great case out of Massachusetts. And it was sent to me by, was it Bernie? Bernie, thank you, my friend, Bernie. And by the way, conclusion, the order denying the motion to suppress is vacated and set aside. The matter is remanded to the Superior Court for further proceedings. So the court said, you got to send it back down, and you're going to get a new trial, assuming you can still do a trial if you've got enough evidence left over after we throw out the video footage and everything that came from it. So there you go. Thanks a lot, Bernie. Questions, comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. When a guy said he invented the cordless extension cord, I had to think about that one.